Hey everybody, how are you doing? It's Boozy back again for Boozy's Legal Funhouse. As we start off with every single one of these, I have to read off the names of the $5 level and above Patreon supporters over at patreon.com/lawyersandliquor. So a special thanks to Jeremy the Head Fox and Dragor, Jack of all Korgs, Nikolai, Tezcat Magic, Jag, Wayland Roche, Beaton, Dozer the Trash Panda, Ada the Weather Fox, Mark Beckwar, Mama T, Uncle Kage, Lisa Lupe, Mark Phaedrus, Netherlinks, Petrov Neutrino, Scott Skunk, Tyranth, Putty Goodboy Esquire, CC Otter, David Hunter, Ed B. Cali, Feck, Ghost Goat, Grace Jane Gallandry, Ian Delahorn, Jackie, Jason Knight, Coma Blood, Paul Maelstrom, Mark Whipple, Matt Allaire, Michael Blocker, Pandemonium Hawk, Sean Rabbit, The Dragon Show, Wheelie, and Zeros Lion. That's it. There we go. And I love reading those off because it's a fun mix of real names and somebody's giant animal character. So, tonight on Boozy's Legal Funhouse, we do not have a guest. It is just me talking to you for the first time recording live for the podcast that was coming out. And there goes that fucking sound that I was pretty damn sure that I actually disabled that. We're gonna turn that off. We're gonna turn that. Like, I was pretty sure I actually disabled the alert box. Like, Jesus fucking Christ. Every time. Every fucking time. Every time. Can I turn the source off? Can I remove the source? Can I do something to get rid of the goddamn source? Because, like, I could have sworn that I turned that off this time. We're going to take that away. We're going to take that away just because I don't want to have to hear it the whole time. Anyways, that said, that's got to be a nice little thing to cut, isn't it? Tonight's topic is real estate law, real property law, the 1L topics, more specifically, the deeding of things and how deeds work. What's a deed anyways? Doing the deed for episode 6.
Rub those bits all over my face.
You know what? I need to check something very quickly before we keep going to discover whether or not it's actually recording those. I can't tell whether it is or not. I genuinely can't. I actually have to watch the recording bar now. Thanks, assholes. You've tossed me completely out of sorts here. So, for tonight's opening, we're going to be discussing at least 3 legal news matters, as we typically do. The first one, of course, is checking in on our good friend Lin Wood.
Rub those bits all over my face.
All right, so it's not actually catching it on the audio. Fuck all of you. Fuck all of it. Like, I'm leaving this in the podcast, by the way. I want people to know that I am completely disorganized when I sit down to do these things. And I can't figure things out. So it's not actually catching that on the recording. So fuck all of you. I'm good. I'm good. I know what I'm doing. That's right. Anyhow, back to what we're talking about. Our favorite update, and that's Lin Wood. Lin Wood, the attorney that you may have seen in that Clint Eastwood movie about the Olympic bombing, who has sold himself to everybody as a crusader of truth, justice, the American way, and lost his damn mind at some point, has been under disciplinary investigation, as we've talked about before here on the Legal Funhouse, and was recently asked to submit to a mental health and substance abuse evaluation given his demeanor in presenting an argument for election fraud. Now, Lin Wood, of course, took a very rational response to this, according to the ABA Journal, and doxed the ethics board. He doxed the ethics board. He went on Telegram, because he's been suspended from Twitter. Of course he's been suspended from Twitter. And he doxed the ethics board. He posted to all of his Telegram followers, all of his Telegram users, a little over 250,000 people, the names and addresses, office and home, of ethics board members in Georgia. I am certain that that will go over well. It says that he posted intimate facts about a board member, including her wedding date, her husband's name, his work as a lawyer, and the city and where they live. When confronted about this, Wood had the very reasonable response of, why are they so nervous about people investigating them? Nobody's harassing them. No one has called for them to be attacked or threatened. I would never do that. And followed up with, They started the fight, but I'm gonna finish it because that does not call for any violence or attacks whatsoever. Lin Wood, everybody. That's right. Lin Wood, completely rational attorney. You're lucky to have him on your side. Moving on from Lin Wood, that is our Lin Wood update of the week. We have to do at least one. It's every week since I've started this, something has happened with Lin Wood. And I don't know how to respond to him anymore. I feel bad for the man, to be honest. I feel bad because there's obviously something going the fuck on there. But, hey, next up is a federal judge has written an opinion in a Too Light beer case. And that opinion, as judges are wont to do these days, is now plastered with alcohol references. That's right. A federal judge in Nevada sent a case regarding underfilled beer glasses back to the state court because its amount in controversy calculation is mostly foam. This is from the ABA Journal of Law reporting that U.S. District Judge Jennifer A. Dorsey of the District of Nevada, Obama appointee, filled their February 12th opinion with at least 8 beer references, rejecting a claim that Red Robin's calculation of the amount in controversy under the Class Action Fairness Act was wrong. It's like this is a class action that is literally over 2 ounces of beer. It's 2 ounces of beer in the Stella Artois. Am I pronouncing that right? Stella Artois? Stella Artois? I don't fucking know. I don't drink beer. Like, I have hair on my testicles. I drink whiskey. The Stella Artois case, Artois. It just sounds better. Artois. The Stella Artois case is over 2 ounces of liquid being short of a pint because Red Robin serves their beer in a Stella Artois pint glass that is apparently 2 ounces shy of being a pint. I have opinions on judges who write funny legal opinions themselves. I got nothing against it. One of the people that I learned the law under was a sitting Pennsylvania Supreme Court justice who had a habit of making rhyming opinions to the extent that other sitting Pennsylvania Supreme Court justices said, hey, can you cut it the fuck out? They're not taking us seriously. I also, though, would like to say that anything that gets people in, anything that draws them to a case and lets them learn about the law or encourages people to read something because it's funny is fine by me, because that's my whole shtick. But the federal district judges have a really good pension plan. Say the step the fuck off of my ground. Because, funny law education, my shtick, not their shtick. They've got a fucking job. It pays well. And for our final part of the legal news roundup tonight, this one's actually fun, and I'm actually going to it's not fun. It's horrible. It really is. It is 2 lawyers got in a fist fight. A former administrative law judge in New York has been censured for punching another attorney outside a party in Manhattan in October of 2016. Beltrani, the administrative law judge in question, was fired from his job as administrative law judge who ruled on parole violations at Rikers Island. He pleaded guilty to a reduced charge of harassment in May of 2018 and agreed to this censure. The basic part of this opinion, I love how they go out of their way to sort of make it not obvious that these were 2 lawyers who were having a rather severe difference of opinion. But Beltrani and the other attorney, Robert V. Beltrani and the other attorney, were at the party celebrating the opening of a friend's law firm when, after availing themselves of the open bar. By the way, not a euphemism. Actually, what's in here, there was an open bar at the celebration, and respondent availed themselves of the bar. Sometime after 11 p.m., the respondent, who was intoxicated, and SR, a legal aid attorney, exited the building and began talking to one another outside. Respondent was standing against the building. At one point, respondent took a step towards SR, and SR extended his arm towards respondent and touched respondent on the chest. The reasonable reaction to being touched on the chest by a legal aid attorney, as anybody with a Juris Doctorate can tell you, is to lay him the fuck out. That's right. You just swing a right hook and you put that motherfucker on the ground. Beltrani, as a result of his actions, has apologized. The legal aid attorney has been the bigger person on this and said, it's water under the bridge. It's over. It's done with. We don't have a problem with that. Beltrani has said that they expressed remorse. They fully operated. They have 32 years of practice with no prior discipline. Their conduct had essentially led to the loss of their job, harmed their legal career. The end of the matter is a public censure, which is essentially a reprimand. It's a reprimand. They were reprimanded over it. And by the way, I would like to dispute the thought that just cold cocking another fucking lawyer while you're drunk outside of a party harms your legal career. There are definitely clients out there who look for that type of fighting spirit in their attorney. I feel that there may be a bit more here than what's being said. I feel that maybe Beltrani and this other attorney had some bad blood, considering one was a legal aid attorney and the other one was the parole judge at Rikers Island. That said, let's move on to tonight's topic. Tonight's topic is real estate law, more specifically, the very basic portion of real estate law, the deed. What is a deed? What is a deed? Can anybody answer that question? What is a deed? A deed is basically a document. It's a piece of paper. It's the legal title to the property. Like when you buy a car and the finance guy yanks you into his office and you have to sign all the paperwork and then they give you a title to the vehicle that proves you own the car, the pink slips. The deed is the pink slip for property. It's a written document conveying the property. That's giving it. That's granting it. That's taking it from person A's pot and putting it in person B's pot to the property itself. And there's several different types of deeds. We should probably start off by making it very clear there are several different types of deeds out there. There's the quitclaim deed. The quitclaim deed is a deed that basically says, fuck you, you get what you get. It is a deed, a very simple deed 9 times out of 10, that says, this is my interest in the property. Whatever interest I have in the property you have, I'm not guaranteeing anything about this property. I'm not going to tell you what the extent of it is. I'm not going to tell you if there's liens on it. I'm not going to tell you if there's an easement, which is a right for another person to use a portion of the property on it. I'm not going to tell you any of that. All I'm telling you is, to the extent that I have an interest in this property, you now have that interest. There is the warranty deed. The warranty deed is sort of like a quitclaim deed, except it's absolutely nothing like a quitclaim deed. I don't know why I even said it's sort of like a quitclaim deed, because in a warranty deed, what you're saying is, I'm warranting these things about the property. I have good title to the property. Everything that's appearing in this deed is what it is now. There's no easements. There's no liens. Nobody else has a right to this property on it. That's a warranty deed, and that's the big one, the last one. Nobody else has a right to this property. We'll get to that in a couple minutes to talk a little more about why that's such a big deal. But essentially you're saying, I own the property and I will defend this property against all other people. If somebody comes to you and they say, hey, that's not your property, that's my property, I'll defend you. I will take care of that issue for you, because I'm telling you right now, as I'm granting you this property, that I have the sole legal interest to it. There's the specialty warranty deed. The special warranty deed is a lot like the warranty deed. Some places call it a limited warranty deed, though, because it will say things like, I'll say to you that while I have owned the property, there have been no superior claims made to this property. So to the extent of my knowledge during my ownership, no condition has arisen that will threaten your ownership of this property. That is the special warranty deed. A lot like a warranty deed, but more limited in what it does. There's the security deed. The security deed, it's a mortgage. I mean, it's a fucking mortgage. A security deed is a mortgage. Yeah, like in some jurisdictions, they don't actually have mortgage documents. They have mortgage deeds, and the mortgage deed is like a mortgage. I should probably tell you the difference between a mortgage and a security deed. All right. So a mortgage is a separate interest in it. It's a fiduciary interest in the land. It's a security for a debt. Like I'll sign a contract that says I owe you $100,000, right? And I put my house up as security for that. I am now the mortgagor. You are the mortgagee. I am giving you the security. You are receiving the security. That mortgage is a separate recordable document that shows the interest in property arising from the obligation I owe you. It is not a deed. I do not hold legal title to the property. What I do hold is the right to foreclose upon the property, to demand the sale of the property to satisfy my debt. Now, a security deed, 9 times out of 10, is actually an interest in the ownership of the property. It's much like when you have somebody written on the title of your car. Believe it or not, when you buy a car and it's titled in your name, but there's a security interest in somebody else, and you can't release the deed or you can't release the title without paying off that obligation. It's sort of like that, except in a security deed situation, they're holding the actual deed as security, not just a right to act on the deed. So there's the difference there. Now, what makes a deed? What makes a deed? Well, generally, and by the way, this is where I should probably say, outside of what I have just said, because that's pretty straightforward and well set out in English common law, which is what we live under here in the United States of America, the English common law given to us by Mother England years and years ago, except in Louisiana, because those weird fucks work under French law. Like nobody understands Louisiana's law except Louisiana. Under English common law, everything I just talked about is pretty common. Now, it varies slightly from jurisdiction to jurisdiction. Here in Pennsylvania, you see the majority of deeds are special warranty deeds, not warranty deeds. Quitclaim deeds are very uncommon because they are special warranty deeds. But that's pretty common. What I'm getting ready to go into now, though, like the general principles of what needs to be in a deed and the requirements of making a valid deed for real estate, that's not a common thing. It can be, but it requires me to give you a disclaimer. And as people who have followed me for a while know, I have a standard disclaimer. Boozy's Legal Funhouse is an educational, informational, and hopefully entertaining discussion of law, legal topics, legal news, and general principles. However, it is by no means legal advice. Yes, I am an attorney. However, I am not your attorney. Unless you have come into my physical office location, sat down with me, discussed your problem in private with me, given me a retainer of my choosing, don't just mail me $1 and say I'm your lawyer, and signed an engagement letter after I have agreed to undertake representation of you in a legal matter. I am not your lawyer. Nothing here tonight should be construed as legal advice or creating an attorney-client relationship. The law is a fickle mistress and varies greatly from jurisdiction to jurisdiction. You will need to consult an attorney in your jurisdiction regarding anything we have discussed or will discuss this evening. Please, for the love of God, no matter what you do not say, "A fat man who pretends to be a badger on the internet told me to do this." I will disclaim you. That said, the following information regarding a deed must appear generally in most of them. You need the names of the grantor being the person who's giving the property, who's conveying the property. And by the way, I'm going to say conveying a lot tonight, so let me just make a blanket statement. Conveying is giving. It is giving something to somebody. The grantor grants the property. They make the conveyance to the grantee, the person who is receiving the property. In general, there will be some listing of consideration. Now, consideration, many people think of it as money, as payment. It does not necessarily have to be. It can be for love and affection, for good consideration. It can be for a nominal value. You can list, and you see this a lot in deeds. a nominal value of $1. It does not mean they have actually been paid $1. It is just a nominal listing of consideration. It must contain a legal description of the property. What is a legal description of the property? Well, a lot of times now, it's the description that appears in whatever your county clerk's or recorder of deeds office is for how that property was. Most people have subdivisions, so it will say, as described in plat such and such, and you'll always know it. If you look at a deed, you're always going to know where that is, because it's going to say something like, being the same property beginning at a point in northwest corner of Ash Street, going 450 degrees westbound 0 minutes, shit like that. All right, and there's something called a meets and bounds description. That's where we place fucking pins in the ground and we have the property surveyed and we use the results of the survey to describe the property, but it's the legal description. And it sounds very complicated to put that legal description in. It's like a full page can be 2 pages. You know how most lawyers do the legal description, though? Oh, this is going to make you scream. The way most of us actually do the legal description in the deed is we look at the deed that was done to give it to you or the person before you, and we just use that legal description. We don't go any further than that. It was good enough to come to you. It'll be good enough to come to the next person. There are mistakes every now and again in that, where they give the wrong measurement or something like that. It doesn't mean you don't own the property anymore. It just means somebody needs to do something called a conforming deed. All right. You need to state the type of ownership, the type of interest that is being conveyed. There's a lot of different types of interest that you can convey in a deed. You can convey a life interest, which is exactly what it sounds like. It is an interest in the property for the person's life, for the grantee's life, that then reverts to the grantor or a designated another party at the end of that life term. There is a tenancy in common. That is 2 people who own a piece of property. There's a joint tenancy with the right of survivorship. That is 2 people own a piece of property, and when one of them dies, the other one gets the whole thing. In some states, there's something called the tenancy by the entireties. Now, the tenancy by the entireties is a special type of ownership of property that is only recognized in about half the states. And it's only for married people. The rule of thumb is it is a joint tenancy that is created between husband and wife during the course of a marriage. Now, the states that tend to recognize this, the District of Columbia recognizes tenancy by the entireties. Alaska, Illinois, Indiana, Kentucky, Michigan, New York, North Carolina, and Oregon recognize it, but only in regards to real estate. They don't recognize it in regards to other type of property. And then a tenancy by the entireties is recognized for all forms of property in Arkansas, Delaware, Florida, Hawaii, Maryland, Massachusetts, Mississippi, Missouri, New Jersey, Oklahoma, Pennsylvania recognizes it, Rhode Island, Tennessee, Vermont, Virginia, and Wyoming. Ohio actually recognizes it too as well, but only if the tenancy was created prior to 1985. They've abolished it since then. Now, what does that mean? Like, what's the importance of that? One, generally it's assumed. Like if a husband and wife buy property jointly, it will be assumed now. Here in Pennsylvania, we used to actually say that you had to put husband and wife by tenancy by the entireties on it. That's no longer the rule. Now the law presumes that happens. There's also something called fee simple. And I should drill down fee simple. Fee simple just means you own it. Fee simple is one person, they own it. Let me go into the Unities real quick. The Unities is interesting. You see, joint tenancies, they have to be created in a special way. And I'll explain real quickly the difference between a joint tenancy and tenancy in common. Because you see, a joint tenancy, it's not a tenancy by the entireties. It's not reserved for husbands and wife like a tenancy by the entireties is. A joint tenancy is 2 or more people owning property, and when they die, all right, when one of them dies, their ownership interest automatically, we say by operation of law, goes to the other people who are joint tenants in the property. because of that. It avoids probate. It avoids all that. Because of that, you have to have 4 unities when you create a joint tenancy. You have to have the unity of time, meaning everybody has to take their ownership interest at the same time. You can't have a joint tenancy to Bob and Cindy and then later add Tim in and have Tim be a joint tenant as well with Bob and Cindy. That breaks the unity of time. It has to be a unity of title. It all has to come out of the same instrument. You got to convey it all to Bob and Cindy and Steve in the same document, the same deed. There has to be a unity in interest. That means that they have to have the same interest. Bob can't have 30% and Cindy 40% and Steve 30%. There's no unity of interest. Cindy has more than everyone else. So they each have to have 33.3 repeating percent of the property all the way up to the end of time. And a unity of possession. And that is an important thing because both under a tenancy in common and under a joint tenancy, all holders will have the right to possess the entirety of the property that is deeded to them. The real effect of the joint tenants by right of survivorship, the joint tenancy, is it transfers automatically upon death. That's really what it is. Now, if you're just joint tenants without the right of survivorship, what you really are tenants in common. And a tenant in common is just 2 people own the property. 2 or more people own that property. It's deeded to 2 or more people. And that's one where you could have Bob with 30 and Cindy with 50 and Steve with 20. All right. Now, there's pitfalls, though, to a tenancy in common. One, it doesn't pass automatically. If Steve dies, his 20% share goes to Steve's estate. It doesn't automatically go to Bob and Cindy. Likewise, in a tenancy in common, you got to have something called partition. And partition is fun. All right, so say that you have received a share of property by tenancy by the entireties under someone's will. Okay? And it's you and your 4 cousins. You each receive 25% by tenancy by the entirety under your grandma's will. All right. And your cousin, Mark's a fuck up. Mark's been fucking up for years. Mark's not going to stop fucking up anytime soon. Mark is a fuck up. He is the fuck up of all fuck ups. He's the fuck up that at the family Christmas, everybody's like, hey, have you seen Mark? He fucked up again. That's Mark. And Mark has sincerely fucked up once more and gotten himself in financial trouble. So Mark's 25% is attached by a creditor. Mark's 25% has been attached. It has been liened by a creditor who has a judgment on it. And now they have the right to conduct business for Mark's 25% of the property. And they decide that they want to seize and sell Mark's 25%. Now, what happens in that situation when they seize and sell? Now that they own that property as a result of their judgment against Mark, what happens? Well, they bring something called a partition action. Because you see, they can't really transfer that property very easily. They can't liquidate it. They can't take money out of it. Maybe if they're nice, they'll offer to sell it to you all. But if not, they can ask the court, hey, we don't want 25% of a piece of property that we can't fully transact. We're a little alienated. That means removed from the benefit of owning this 25% of the property. All right. So they go in and they say to the court, we're alienated. We want something that lets us transact this property. And the court says, okay, we'll partition it. And what's a partition? Well, it's a court for sale. Whether the other people like it or not, if you went into partition action, the court forces the sale of the property and then divides the assets up amongst the owners, the realization from that sale. So this creditor could take that 25% interest and bring for a $10,000 judgment. Let's say a $10,000 judgment. Say the property's worth easily $100,000. The other 3 people don't want to sell it and they don't want to buy it off of them. They bring a partition action. They force the sale of the whole property. And now after cost of sale, they get maybe $20,000. They've doubled their investment. Now everybody else has been dispossessed of their property. They are pissed. But Mark's a fuck up. We covered this. And why is that such a big deal? Like, why is it such a big deal when that happens? Well, because it's still happening. The ABA Journal on February 1st reported on how Jim Crow-era laws will tear families from their home. And what they're actually talking about is they're talking about the division of property under statutes of intestacies. That's people who did not have wills devising or stating how property should be divided up, would be divided up many times under a statute of intestacy that would take property like that and divide it up as just like we talked about. Like 25% to all the heirs equally, but they all held it as tenants in common. And these are old laws, disproportionately affecting African Americans who would not have wills at that point. And what they would do, and there's people who do this, they go out, they track down a tenant in common with a small interest in the property. They offer to buy that small interest in the property for far less than the percentage value of the property, and then they force the sale of the property. They force the partition sale of the property, forcing those people out of their homes so that they can realize a profit from the sale. As the ABA Journal has discussed, there's people who are fighting it. There's people who are fighting it in there. A 69-year-old gentleman, Ronald Henry, has said he was blindsided to find out that a trust had purchased a half interest in his home in San Antonio, where he had lived since 1978, after he discovered his brother, who he hadn't seen in over a decade, had sold his 50% share in the house to an investor that turned around and began claiming a right to charge him $375 a month to continue living in his own home, which is something you can do. If you are a tenant in common, with a right to the whole of the property, you can demand rent for somebody living in or using your share of the property. Same thing really with joint tenants, even by right of survivorship. But a joint tenant can't really partition the property like that without severing the joint tenancy and losing that benefit. He's still in court about this because that trust, the San Antonio Arts and Entertainment Revocable Trust, has sought the partition and sale of the property at this point. And it's happening, especially in those areas where people are gentrifying the neighborhoods, where they can track down a person who holds a tenancy in common interest like that, by way of a statute of intestacy, the heirs property distribution that did by tenancy by the entireties, who has no interest in the property anymore, offering them a sweetheart deal, then forcing somebody who has an interest in the property and may have owned it as a half tenant, but has been using it as a home, has been paying the taxes on it, has been doing all that for decades, forcing them to sell or charging them rent for something that they owned free and clear just the year before. And when they won't do it, they force the sale. It's inequity. An equity and law that can be avoided simply by the careful crafting of a will to say, and my property to my children, to be held as joint tenants with right of survivorship, or something like that, where you can't really sell that interest. Now, I say that, but it's not true. Because you can do something called severing a joint tenancy. Somebody, like a tenant in common, can pledge their interest to someone else, right? A joint tenant, generally it's not reachable a lot of times on an interest, but a joint tenant's interest by right of survivorship can be transformed to a tenancy in common by the act of severing the joint tenancy. That tends to happen when a joint tenant has a lien entered against them, when a joint tenant pledges the property, does anything that conflicts with the joint tenancy. And that severs it, and as to that person, renders it a tenancy in common. So let's go back to Bob, Cindy, and Steve. All right, so Bob, Cindy, and Steve are tenants are joint tenants with a right of survivorship in a single piece of property. Steve decides he is going to pledge his interest in the property as security for a loan. All right. He then defaults on the loan. Steve has severed the joint tenancy. Steve is now a tenant in common. But is he a tenant in common with everybody, or is everybody now a tenancy in common? Because Bob didn't want to sever it. Cindy didn't want to sever it. They were happy being joint tenants. So who's the joint tenant? Bob and Cindy remain joint tenants as to each other. When Cindy dies, the 50% or the third that she owns of the property will automatically go to Bob. However, when Cindy and Bob die, if Steve's still alive, well, he doesn't automatically get that 100%. All right? He's lost that right. He severed it. Steve, from there on out, will only own 1/3 of the property. Whoever's the last man standing among Cindy and Bob, that's the one who will own the other 2/3 and be the majority owner of the property. All right? So they sever it as to all other tenants, but they don't sever the joint tenancy as of tenants. And why am I going into all this right now? Because this is about deeds. I hear you. I hear you in the distance. Boozy! Boozy, you're saying. We didn't tune in about property ownership and titling matters. We wanted to talk about deeds, said absolutely fucking no one who's never been a 1L law student. We didn't tune in to do that. Because all of that is something you place in the deed itself. It's right there. From Bob, in fee simple, to Cindy and Steve as joint tenants with right of survivorship. By the way, the wording of a deed, very important. There are cases out there that say we do not presume to create. Depending on your jurisdiction, I always have to say, you have to review your law. But we do not presume to create a joint tenancy by right of survivorship. It has a special class in law. So, if you just put joint tenants, they may not, depending on your court, read in those last words, with right of survivorship. They may say, well, you said joint tenants, but not right of survivorship. We're not going to presume you want a right of survivorship. We're going to make you tenants in common. You can say with tenants in common. Or if Bob and Cindy are married, because remember, a tenancy by the entireties, where it is allowed, is only recognized between people who obtain the property during the course of the marriage. By tenancy by the entireties. So the specific wording in a deed is very important in determining the type of ownership interest that is out there. That slurping sound, for those on my audio file, is me enjoying coffee at 7:36 p.m. So you can see why all that's important, because it has to be in the deed initially. Now, there are other requirements for deeds outside of that. By the way, they generally have to be notarized. I'm just putting that out there. Like, you generally have to notarize a deed. You can't just like say they signed it. A deed between that, though, there has to be like legal competence. The person who's signing the deed, who's handing over the property, does have to be legally competent to do that. There's actually a good case out in, where was it? New Jersey, I think. What was it? New Jersey? Yes, it was New Jersey. There's a good case on this question, which was it Herman v. Mortensen? No, God, Armstrong B Anderson. Was it Armstrong? Yeah, it was Armstrong B Anderson. Armstrong B Anderson is actually an Oklahoma case. I misspoke earlier. From 1966 on the question of competency for a deed. Competency for a deed. And in Armstrong v. Anderson here, I'll flip over to it real quick. Armstrong v. Anderson is one of those cases where you read the facts and you kind of go, what the fuck? Like, really? Armstrong v. Anderson was two little old ladies were in a nursing home. All right, they were generally alleged to be incompetent to transact business, and their nephew came in and suddenly walked back out with the deed to their properties. Now, at some point, the brother of these two little old ladies, who were Lula Armstrong and Mary Nickerson, who were 79 and 77 years of age, came in and said, well, wait a second, how can that happen? My sisters are mentally incompetent. They could not understand what they were doing, and that really is the question. As Armstrong v. Anderson goes on to point out, the question of competence and the execution of a deed is that they know what they're doing, and they appreciate what they're doing. They know what they own, and they know that they're transferring it to somebody else. It's not a question of do they completely understand everything around them. So that's the question for competence. But if you can show at the time of the transferring of a deed, at the time of execution, that's where everything's kind of locked in, is right there at the time of execution, the time they sign it, the time it's right in front of them. If you can show that if they were not competent to execute a deed at that time, well, guess what? That's not a valid deed, because the parties to it were incompetent. A lot of things, especially with deeds, are very similar to contracts to some extent, especially in regards to competence. Finally, there must be acceptance and delivery of a deed. That is, the person who is being given the property must accept it. They have to say, oh, okay. And the person who is handing over the deed has to actually hand it over. But it wouldn't be law if it was actually that fucking simple, right? Because what's acceptance? Is it like Michael Scott in The Office standing there, I accept this deed? No. The law generally will presume that if something is of value, if it's beneficial to someone else, then they will accept it. All right? So the law will presume that a gift deed, a deed gifting you a piece of property, is being accepted by you because it is to your benefit. And what about delivery of it? When does delivery happen? Does delivery happen when it's handed to you? Well, yes, certainly. When somebody signs a deed and hands it to you, it has been delivered. But what about, you're closing on a house? I've closed on a house. When I closed on my house, nobody handed me a signed copy of my deed. It went to my title insurance company. My title insurance company had the signed copy of my deed. And they then gave it to an office downtown. I still don't have a signed copy of my fucking deed. I've never received a signed copy of my deed. I pulled one offline, but I don't have the original of my deed. Why don't I have the original of my deed if it's been delivered to me? Because there's things that we call conditional acceptance and constructive acceptance of delivery. Constructive delivery is where you hand it to somebody on behalf of somebody else. Conditional delivery is where it's only going to be delivered at a certain time. And how do we determine that? Well, in general, we have to look at the facts. We have to look at the facts to determine whether or not the act of delivery has placed the deed so far out of the grantor's control that they can't just merely decide not to go through with it. That's the question. Have you placed it in the hands of a third party who is not answerable to you, where you cannot demand it back? Because a deed technically should be valid upon execution and delivery. So if I can write out a deed right now, giving my house to any of you wonderful people, and I walk over to my fictional safe in the corner, that's right, my fictional safe where I keep all my fictional money, and I place it in there, and I never tell you that that deed exists, and I never give it to you, do you own my property? Have I conveyed my property to you? No, I have not. I have not conveyed my property to you because at any fucking point I want, I can walk over to that safe, take that deed out, and set it on fire. I can burn it. Matter of fact, I may burn it. It's not a fictional lighter, but I definitely have a lighter here beside me, right? Somebody in there has just said, for all of you who are listening on Wednesday, we record these live, and one of the people on the live has said, you got to file it with a clerk, right? I'm getting to that, but no, not necessarily, although that is certainly a form of delivery. I have the right to destroy it, to retract it at any time, so it has not been placed out of my control. And finally, a deed must be delivered within the life of the grantor. Delivery cannot take place after my death. I can't just leave that deed in my safe with a note taped to the front. The house is deeded to Jeremy the Head Foxen. And have somebody find it and hand it to Jeremy later. That doesn't work. because it was never delivered in my lifetime. It never so left my control that I could not bring it back within my lifetime. So that should answer that question on delivery. Now, it should answer the question on delivery. However, I do have to say there's at least one question here that I want to get out there, and that is a case. This one is actually the one I believe out of California. It's Herman v. Mortensen, and it's actually a very similar case to what we just talked about, delivery of the deed. You'll find this at the California Appellate Second Division. Herman v. Mortensen. It's a 1945 case. In that case, a lady had deeded the property to her good friend and then handed it to her attorney who prepared the will, stating that she wanted it delivered on her death. She died. The question became, who owned the property? Was that an effective delivery? Could it be taken back? In this case, what had happened is, they said, yes, it can. And the pause was intentional. It was to give you time to yell no. It can, because upon delivery of the deed to her attorney to be placed into a safe, the grantor had essentially made the attorney a fiduciary, an agent, holding the deed for the benefit of another, being the grantee, whether the grantee was really aware of it or not. And in that situation, they had placed it beyond the control of the grantor. So in that specific case, they held yes. Now, I'm certain that if we look out there, there are plenty of cases that say, no, you got to do more and give it to your lawyer and say, put it in your safe. But there's at least one case that said that's exactly what you can do. Now, somebody earlier had said, when do you hand it to the filing clerk, to the clerk's office? Depending on where you are, it's called different things. Here in Pennsylvania, we call them the recorder of deeds. Back where I'm from in Kentucky, we called them the county clerks. And it is an office that takes deeds and documents concerning land and records them. And I don't mean they take out a VHS camera and pan down it. We've had it for a while. But it essentially is making an official record of the grant of property to another person. All right. That is a good question, and I have 3 answers. And all 3 answers are, it depends. It depends on where you are, because we have 3 different types of jurisdictions regarding that. We have the race jurisdiction. We have the notice jurisdiction. We have the race notice jurisdiction. And what does all that mean? Well, the notice jurisdiction is probably the easiest one. The superior deed, the one that's effective, is the one that is taken without notice of a superior claim. All right. So in that situation, let's say Bob and Cindy. Bob is deeding his property to Cindy. All right. He deeds it to Cindy. Then he turns around and he deeds it to Steve. All right. There's 2 deeds out there. Both are fee simple. Both purport to transfer 100% ownership. Who owns the property? Well, Steve could. Right? He took it without notice. He kind of has the superior claim, doesn't it? But if Bob had said, hey, I'm giving this to Cindy. I'm giving this property to Cindy now, and then I'm going to turn around and I'm going to sell it to you. Who owns it? Well, probably Cindy. And I say Cindy because that's it. Now, in a race jurisdiction, it's all a question of who records first, who takes it down to whatever your county office is and gets it on the record. So same thing, except Bob sells to Cindy, turns around, sells to Steve, same property, 100% interest to either of them, and tells Steve when he sells to Steve, hey, last month I sold this property to Cindy. Cindy has been busy. Maybe she's been watching the Great British Bake Off. Who the fuck knows? But she hadn't gotten her ass down to the courthouse to record that deed. All right, so Steve runs down to the courthouse. He records it. 2 days later, Cindy goes in and records it. Steve then tries to sell the property to another person. Cindy tries to say, no, you can't do that. They sold it to me first, and you had notice of it. All right? It doesn't matter. It does not matter whatsoever. And the reason it does not matter is because Steve recorded it before Cindy, and first in time wins in that situation. So Cindy's paid for nothing. Maybe she can go after Bob. Maybe. Then we have the hybrid model, and that's the race notice jurisdiction. The race notice jurisdiction is kind of a combination of the first. So Bob sells to Cindy. Bob then turns around and sells the same 100% interest to Steve. All right. Now, Cindy goes down and records first. Cindy's always in. She won the race. She's there, right there. And I should say right off the bat, and I'll explain why in a moment. In any of these situations where Cindy records before Bob tries to record, Cindy's going to win. Or before the sale to Bob, really. Cindy's going to win. All right? But say Cindy doesn't record the sale before Steve does. All right? Does Steve? Then we look at, did Steve know about the prior sale? If it's no, well, then we say who afterwards recorded first. Right? Because you see, if Steve knew about the sale, Cindy's going to win anyways, whether it's recorded or not, because it's race and notice. It's both of them. Afterwards, then we hit that race part. Who records first? If Steve, with notice, or without notice, records his deed before Cindy, Cindy has nothing. And it sounds very complex. It sounds very strange, but the fact is, this is something that happens. We call them wild deeds, or as I prefer, wildcat deeds. Deeds that are hanging out there, where you got Bob, who sold his property to 5 different people, and you got to determine who has the actual right to transact that property and sell it in the future. All right? Because Bob's a dick. Bob and your cousin Mark have gotten together to figure out a way to fuck everybody out of the family house. That's what's going on here. But anyways, the idea, though, is that we shouldn't be allowing that to happen. But at the same time, there's got to be some limit to when someone can just sit a deed down and forget it exists and still be able to move forward with it. Generally, if the next person takes it without notice of the sale and records it in a timely manner, they're fine. And why does that work? I mean, why does that work? Why is it okay for this person to completely deprive Cindy of their ownership interest if they didn't know about the prior sale, but they happened to record before Cindy did? And Cindy sat on it while they were sitting on it too, but not if they did know, or not if Cindy records first. Well, the answer is something we call constructive notice. And this goes into title insurance and title searches. With the title searches where somebody traces back every single recorded deed. If you have a really good title agency company, all the way back to the first person to own the fucking property. Goes all the way back. Constructive notice, and it's really the purpose of recording, is there is a legal record out there. And through a reasonable and diligent search, you should have found it. Whether you did find it or not is completely immaterial to the question. It's completely immaterial to the question because it's out there. All you got to do is get off your ass, turn off the bake-off, go down to the Recorder of Deeds office, and take a look. Take a look, motherfucker. And you think that doesn't happen very often. You really, really would. You would generally think it doesn't happen very often. But one of the great cases on it in my area is from the New Jersey Superior Court from 1985, where exactly this thing happened. Somebody transferred property. Isaiah Adams got property in 1859. He divided that property up, made subsequent conveyances. Those conveyances went to people. And then Paul Burgess Sr. in 1922 became one of the most renowned titlemen in New Jersey. While not a lawyer, he was very knowledgeable. He spoke to people. He put it out there. But before Mr. Burgess died, he and another person began transferring pieces of property, and they transferred them to other people who didn't record the deeds. And the central question, the case here, is once again Highland v. Kirkman. You can find that at a Reporter 498 A2D 1278. The central question here was, who has the right to the property? How many wild deeds are out there, and should they be stricken off, or should we look at this? And you would think that this is a short case, but it's not. It's like 20 fucking pages. This was a long case going into that exact question. Who owns the property? You ever wondered what title insurance is? This is what title insurance is. This is part of what title insurance does. It makes sure you're getting a good deed to the property, a good interest in the property, and it insures you against judgment liens that can let somebody else come in and take your interest in the property, diminution in value due to easements that are unrecorded, wildcat deeds and defense actions. I always tell clients, get title insurance. No matter what, get the fucking title insurance, because it's a small investment overall for a long-term gain. And somebody, oh, well, those are outlying cases. And maybe they are, but do you want to lose your fucking house over an outlying case over being the one guy who didn't get it? Jesus Christ, it costs like $600. Buy the fucking title insurance. Oh. Anyways, that runs down the deeds. And do you have to have a physical deed? What's the effect of a physical deed these days? What does it matter? I just covered that the official copy of the deed, the one that's transactional, is the one that's on record with the recorder of deeds or the county clerk or whoever's recording those documents in your county. So what's the effect of a physical deed? Are we like back in the Old West with the Snidely Whiplash-looking motherfucker twirling his goddamn mustache? Sweet Sue, I have the deed to the lumber mill. No, we're not, and we've never really been like that. Like, there's always been some office that keeps a chain of title on deeds and things like that out there. Like, I've got the original deed to my house. I got it. It's old as fuck. It's definitely a historical document. But I've seen deeds that come in and they've got the little fucking tax stamps on the top to show you paid your transfer taxes when you bought the property. There was never really a time where just having the deed in your fucking hand automatically meant you owned Sweet Sue's lumber mill. That didn't happen. All right? It's a common misconception. I'm not saying that having the original deed in your hand can't help. They'll see what your signature looks like. They could alter that deed and try to record the altered deed as being one that's conveying the property to them, 3 days before you. There's certainly things you can do with the original of a deed that can make it an issue. But all of them involve some other step in malfeasance. It's not just I own the deed, so I own the property. It's sitting in my back fucking pocket with one of those big gold seals that reads deed on it like they do in the fucking Looney Tunes. It's the same thing as your car. Okay, look, if you're one of those fucking morons who keeps the title to your car in the glove box of your car, and I know some of you are, don't even try to fucking deny it. If you're one of those fucking morons, the simple fact that somebody breaks into your car and takes the title out of your car doesn't mean they own your car just by virtue of having the title. You know what you fucking do? You right into the state. You say, I lost the title. I need a new one. Same kind of thing here. All right. Now, they can certainly do things with it. They can forge your signature to make it look like they've signed the car over to you or to them. That happens. But just having it in your possession makes no sense. So there you go. I'm ruining childhood cartoons for you now to let you know Snidely Whiplash wasn't really getting Sweet Sue's lumber mill when he got the deed. That's me. I am Boozy, destroyer of childhood fantasies. Damn, that man had a good mustache though, didn't he? Like, wouldn't that be great if that was just how property transfers took place? You kidnap someone and put them on the train tracks until they hand you the deed, and then you're fucking done. And like, not even adversarial ones, just like normal ones. Like, that was part of closing. You kidnapped somebody, tied them up, and stuck them on the fucking train tracks. That'd be wonderful. I'd love that. It'd certainly make my job at a real estate closing much more interesting. So we've gone over the importance of deeds and the words of conveyance and how they're addressed and how you determine who has superiority in title based on when it's recorded or if it's recorded or who has notice, and the different types of ownership and wildcat deeds. In a very quick review of competency, what else is there left to talk about tonight? Well, every week when I do this, I ask my Patreon supporters for questions regarding whatever the topic for the week is. So let's flip over and take a look at any questions they may have had. All right. The first one here is from Ezraya. At some point before I bought my property in 2016, my neighbor to the left side expanded his accounting office. When I look at the GIS data and the property boundaries in my deed paperwork, it looks like about 4 feet of his expanded office is on my side of the property line. What should I do about that, if anything? Well, this is a very specific situation, so what you can or should do is hire an attorney in your state and go take this to them, because I'm not your lawyer. What you are talking about, though, is an actual legal thing. And what you have to look for is a concept that we'll talk about more in depth in a future episode called adverse possession, which was the existence of many law school jokes and flirting come-on lines like, I'm going to adversely possess dad ass. Because, yeah, law students are nerds. We're nerds like everybody else. Even our sex is boring. Yeah, I'm going to adversely possess that ass. Adverse possession is a concept of law. I'm not going to go too far into the details of adverse possession. It is a concept at law where somebody has possessed the property, normally with notice in an open and notorious manner that the actual owner of the property should be aware of it, for such a period of time that they have, in effect, gained legal title to that property. And there's a lot of elements to it. Open and notorious, hostile, which doesn't mean like you're taking pot shots at the owner. It does mean that it is against the owner's interest. You're making it really clear you're not there by permission. You're there because you think it's your property, or you're going to treat it as your property. So it's hostile to their ownership interest in the property, not you're taking fucking pot shots at them. And when you hit the period of time, you can claim legal title. Now, there's something called tacking, and that does not mean that if you own the property for 2 years and somebody's been using it for 30 years, that they can't still do it. Tacking means that the transfer of the interest to you by the prior owner adds on to their time. So it'd be from the date that they started using it and the uninterrupted use continued, and it tacks on to every successive owner of the property they're using. All right, so if Bob is using 4 feet of Cindy's property for 10 years, and then Steve buys Cindy's property, Bob doesn't start back over at 0. He gets 10 years plus however long Steve's got the property. And if Steve sells it, he gets 10 years plus Steve's ownership. And what's next? It's called tacking. It exactly what it sounds like, puts a fucking push pin in and attaches it to the next owner's interest. The jurisdictional limits for how long you have to hold the property and how the elements are defined and things like that, that's very jurisdiction specific. I could not answer that. It is generally long enough that you would expect somebody to know about it, to know about the non-conforming use. In Pennsylvania, for example, it's 21 years. So I would certainly suggest that you go and speak to an attorney in your jurisdiction and ask them, hey, are they adversely using my property? Or, hey, do they have an easement to use my property? An easement is a right to use the property. It's not ownership of the property, but it's a right to use the property. And generally, most easements are recorded, much like deeds, so they would be of notice and on title. I would very much suggest you speak to an attorney about that. And I would suggest you do it sooner rather than later, because if you were in, Pennsylvania right now, I know you're at least almost 5 years at the least into the 21-year period, and depending on how long the prior owner had allowed that usage to go on, you may be outside of it. Now, I say allow it, and I have to be very clear. It's not allowing it so much as not taking action. Because if you allow somebody to use the property, if you consent to it, if you give them permission, it's no longer hostile. You're not on the property in a hostile manner. Somebody's given you permission to be on the property. That can break the adverse possession timeframes. Head Foxen has stated, according to the township's plat map, my property line ends a good 2 feet before the back fence gate that leads into the alley. According to the town's map, the end of our alleyway, that slice of my yard and part of one neighbor's yard, all belong to the house opposite mine across the alley. The alley has been like this for quite a long time. If the property owner found out, could he force us to give up our property? It depends. Once again, you have to go to an attorney in your jurisdiction. I would argue that if the property owner is aware of it, then you likely, because tacking works both ways, you can take the interest of the prior adverse possessor on it. You can say, yeah, I've only been here a year, but little Jim, well, he was adversely possessing your property for 40 years. That tacking works both ways. It works against that owner and it works in favor of the adverse possessor as well. So you could be past that right now. And I would strongly suggest a survey, and B, speaking to an attorney in your area to determine what you need to do. Maybe what you need to do is bring what we call an action to quiet title, which is how we determine ownership of property. We determine it by the bringing of an action to quiet title, an action to tell the court. It's not like walking into the title's bedroom at night and going, "You damn kids, shut up, I'm trying to sleep." It's an action to quiet disputes regarding title, would be a better way to put it, that resolves property disputes, much like the one you just talked about. I would specifically suggest you go and speak to an attorney in your jurisdiction familiar with that area of law. Let's scroll down and see. Dear lawyer type, my mom is saying write your name on the stuff you want me to leave you when I die, so I wrote my name all over the house. I wrote in obvious places and hidden places. Is this enough to stand up in court? I don't even need to see the name to know who that is. No. Your answer's no. You smart-assed motherfucker. Absolutely not. We don't play dibs in the law. You don't just get to say it's mine. Take it. Have your mom write a will. Let's see. I have another one that's not sure if this falls into a similar category. My great uncle passed away when I found out from my grandparents they wanted me to have the trailer we lived in. His kids agreed to sign it over to me. I gave them a deed. They said they'd have it notarized. They returned it to me unnotarized. I filed it away and been living here for 3 years. I recently looked at the paper and it was never notarized. They gave me back the folder. The trailer is too old to be legally moved anywhere, but I feel I should be worried. Advice on how I might fix this issue. I cannot give you legal advice. I'm not in your jurisdiction. It's right at the beginning of the stream. What I can tell you is, once again, speak to an attorney in your area and in your jurisdiction, because property law varies widely from jurisdiction to jurisdiction, and you have something different there. You have a trailer, which they're not trailers anymore. They're manufactured housing. You gotta be okay with that. They're not mobile homes. They're not trailers. They're manufactured housing now. I can tell you in my jurisdiction, manufactured housing has a special status under the law, really, because the manufactured housing unit itself is not considered property in the form of real estate. It is, unless the title is merged with the land, considered like a vehicle. That's right. PennDOT actually issues titles to manufactured housing in the Commonwealth of Pennsylvania. It's taxed separately. It's assessed separately. You pay a different manufactured housing tax for it, and then you pay one for the land if you own the land it's sitting on. What people tend to do when they have it situated on a piece of land that they're going to own is they tend to cancel the title to it. And then when you cancel the title to it, then it becomes an improvement on the property, which actually brings up something I didn't mention earlier. Does a deed transfer a house? Many people are going to tell you, yeah, I have the deed to my house. But you don't have the deed to your house. Read your deed. What's being transferred to you is not your house. What's being transferred to you is the land that your house is on, with all improvements thereon. Most of the time, all the deed is transferring to you is the land, with any improvements that are on it, your home being one of those improvements. Now, I have seen deeds, especially in cities, that will specifically identify the structure. However, most of the time will be being such piece of land located at, and you go into the legal description, and then at the end it says, with all improvements and appurtenances and benefits thereto. The improvements include your home. So that's an interesting piece of fact. And it's actually kind of a stickler in law. Real estate contracts for the sale of land technically could be enforced based on the fact they have agreed to sell you the land. If the house burned down, then they would still be able to say, no, you're bound to buy the land, not the fucking house. Read those. Now, of course, there's plenty of cases out there. And most real estate contracts are actually drafted such that the value of the land for most people is recognized as being the house. And if the house is gone, there's a diminution in value. It's a material aspect of the contract. But it's a fun thought, isn't it? That's why you'll see risk of loss and things like that, and diminution in value and repairs to the improvements, and the improvements specifically mentioned in real estate sale contracts, because most deeds are simply for the land, not the house on the land. Tyro Thunderdome has asked me what is the funniest deed story I have. I don't fucking have funny deed story. What the fuck do you think? Why do you think there's such a thing as a funny deed story? Like, man, I tell you what, that transfer of the 3-bedroom, 2.5 bath down on State Street, hooey, that one was a knee slapper. There's no such thing as a funny deed story. Like, there's funny real estate stories. There's funny property law stories. There's no fucking funny deed. So what do you think? Like, I'm transferring the deed to a circus? Jesus Christ. Somebody has also guessed the name of the Supreme Court justice that I was mentored in law school. The Pennsylvania Supreme Court justice that mentored me in law school as for trial work. Yes, Quaxum, you are correct. I will say, I'm not going to say their name, but yes, you are correct. And with that, I'll turn for the last 15 minutes or so to the general chat to see if anybody has any questions about deeds. Keep in mind, tonight's discussion was specifically about deeds. All right, it was not a general property law primer. They teach an entire course on this shit in law school. All right, deeds are just the beginning of property law. The rest of it is much worse, like the rule against perpetuities and when an interest vests and things you don't care about, but at some point in the future I'll likely bring back to you because there's only so many topics we can bring up. I love this one right here. I would argue a funny deed story would be Who Framed Roger Rabbit. That's actually a good question on that, because you see in Who Framed Roger Rabbit, the plot revolves around the hidden deed to Toontown. Who is the owner of Toontown, and with the deed not out there leaving Toontown, who would own it? And the thing is if he had heirs, then it would have been transferred either under the will, or it would have transferred, if he had no will, by the statute of intestacy to his heirs. So the question is a deed written in invisible ink, such as that from Who Framed Roger Rabbit, going to be valid? Well, let's apply the thought process we had tonight. I mean, it had a grantor, yes. It had a grantee, no. It didn't. The grantee was not a specific party. The grantee was the Toons. Are the Toons a singular legal entity? So right off the bat, he can't just leave his... That'd be like me saying, I leave my property to the Bobs. What Bobs? Every Bob? Does every Bob own a piece of my property? It makes no sense. Even the Toons of Toontown isn't limited enough. You have to identify a grantee. Now, the Toons LLC, I could see. The Toons Living Trust, maybe. Yes, those would be viable ways to do that. But you couldn't just say the Toons and get the fuck away with it. That's not how this shit works. So right now, we've already said that's not a legally enforceable deed. Toontown's got to be razed by the state of California to build a fucking highway. That's right off the bat. It's happening. Get the dip fired up and roll it down the street, motherfucker. They can sing a song to the cartoon sun as they melt away because someone didn't know the proper way to convey property. All right. Secondly, would it have been delivered before death? No. The deed was never out of his control. He didn't actually give it to anybody. If you remember correctly, it was sitting in his office. There was no delivery. Roger just picked it up to draw a picture for Jessica Rabbit. All right? That's not delivery. It was still within his control at the time of his death. And as we've covered tonight, you can't actually transfer property. You can't make delivery after death. The delivery has to be made prior to death and generally around or at the time of execution. So there we go again. Fire up the dip machine and melt the fucking animated sun. There we go. It's done. It's done. He couldn't deed it. That deed has no legal effect. California courts will throw it the fuck out. All right? Even if it was effective, he didn't give any words of conveyance to delineate whose interest is what. Like, he didn't give it to one person. He gave it to all of them. So let's ignore the fact that it's definitely not a valid deed. That Who Framed Roger Rabbit did not have a valid deed. Let's just completely ignore that for a moment and act like it was delivered in life to somebody that accepted it and the Toons of Toontown are a specific enough identity of the grantees. All right? Every Toon of Toontown now has a fractional share of Toontown. Every single one of them. You gonna tell me not one of those motherfuckers is gonna sell their fractional interest to Judge Doom or any of his compatriots because he didn't do that on his own? And they're not going to turn around and force a partition sale of the property? Are you gonna tell me that's not gonna fucking happen? I guarantee you that's gonna fucking happen. By the way, wouldn't Judge Doom, being a Toon of Toontown, have received a fractional share as well under that deed that he took a vested ownership interest in prior to his own death, therefore making his share passable to his heirs? Do Toons have heirs? I mean, you see how this wouldn't fucking work? When you examine it under actual real estate and property law, especially in regards to deeds, the entire impetus for the plot of Who Framed Roger Rabbit falls the fuck apart. It falls apart. It does not stand up to basic legal scrutiny. I feel better now. I feel better. That has made me feel better. I've destroyed both your Snidely Whiplash fetish and the entire plot and impetus for the plot of Who Framed Roger Rabbit in 1 hour. Do we have any other questions? Or have you all learned your fucking lessons on asking me anything? Huh? Let's scroll up. Can you refuse a deed that someone leaves you in a will? Actually, yes. Yes, you can. Okay. It is called disclaiming. All right. It actually goes more into estate work than deed work. A person, though, has a right to disclaim an inheritance. It does not happen very often. As we said earlier, it is presumed that you are accepting anything that is beneficial to you, and it is presumed that these things would be beneficial to you. All right. Especially, who wouldn't want free land? It's free real estate. Who wouldn't want that, right? But you can actually disclaim. You can say, I don't want it. I don't want it. Pass it on to the next person. You can refuse a deed. If somebody comes to the lawyer, you can fucking scream no and throw sand in their face and run in the other direction, or you can just say no, or write them a letter, say rejecting it. And in regards to wills, you can file something called a disclaimer of interest that says, hey, any interest I'm getting under this, I don't want it. Give it to the next person. All right. Now, it does have consequences. It can have tax consequences. It can have benefit consequences. Say you're on government benefits. There are cases out there that say if you're receiving government benefits, what they are actually counting is not whether you actually receive the property, but whether you have the right to receive the property. And they may count it as that case against your assets for a period of time. But you certainly can refuse to take an interest in property if you do not want it. Yeah, Dr. Quaxum out there has made a question. Let's see if we can find it, Quaxum, regarding property on a deed that no longer exists. Like if seismic activity actually measurably changes the property as described on the deed, what happens there? Generally, there's going to be a resurvey of the property interest. There will be more than likely some court matter to determine ownership, and we'll reset the deeds when it happens. What happens in those situations? It does happen every now and again. Property is created, property falls apart. Who takes ownership of it? Many times we look to legal precedent to determine it, and if we can't determine from legal precedent or that sort of thing, then what we'll do is somebody will bring an action to quiet title, and the courts will simply determine how the property is, and we move forward on that. Dr. Rob also says, I assume some states have laws regarding deeds affected by geological activity. No clue. I'll just be blunt. No clue. That happens so infrequently because what would have to happen is the geological activity would have to so change the description of the land that it no longer meets the legal description in the deed. Like if a stream changes course and comes across your land through a survey document, it does not mean that the stream is not part of your land because it has come in. That's why we don't set off these things. 9 times out of 10 is by things like rivers or stuff like that. We set it by geological landmarks, things that are unchanging. If you ever come across an iron pin on your property, that's a survey stake. It was done during the initial survey of that. Science has asked, if you owned a 50% stake in a house and property and do something which reduces the value by 50%, do you lose your stake? No, you honestly don't. Maybe your co-owners, maybe your tenants in common or your other owners can bring an action against you for the diminution of value. But the general rule of thumb, even with the tenancy in common, is even if you only own 10% of the property, it doesn't mean you can't only use 10% of the property. Generally, you can use all of the property. And there's other things that go into that, okay? There's questions about who has the right to take timber from the land. When you have that. And many times, anybody can. Anybody with the ownership stake can. Now, maybe you have to disgorge some of that to the other owners of the property. So maybe if you do something that removes 50% of the value of the property, you would have to disgorge any benefit you received from it to other owners to an extent. Maybe you could be held liable for the other by the other owners for the diminution of the property. But no, you don't lose your stake. You have lost your stake in the form that you have diminished the value of the property to everyone else. And like I said, maybe they can bring an action against you to get some of that value back. Or if you, for instance, sell mineral rights to it, maybe you would have to actually give them some of the proceeds of those mineral rights as well. Speaking of which, I should say, when you purchase property, you are buying it all the way to the sky and all the way to the center of the earth. That's right. You own that piece of property all the way up and all the way down with some limitations. However, and this is very interesting, those rights are severable. Okay, if you look at a deed, and you'll see this in areas where they sell coal, where they have oil, things like that, you'll actually see in the deed somewhere, many times, something that says not granting any mineral rights. And that means that whatever things are underneath your property, the coal rights, the oil, that doesn't belong to you. You own only the surface. You don't own what's below the surface. And you get into areas where there's coal, there's oil, things like that, that'd be very hotly contested. You'll see entire lawsuits brought over who owns the mineral rights. Does the person who bought the house own the mineral rights? Has it ever been conveyed? Should somebody have told you that the mineral rights were conveyed in the past? As a matter of fact, in Pennsylvania, there is a disclaimer for property in certain areas where they know they have coal deposits that you must say whether or not the mineral rights are being transferred or whether or not the mineral rights have already been transferred as part of a transfer of deed. So that is actually a huge thing. Are homeowner association restrictions put on a deed, or is that a separate document? That's a good question, Cayenne Coyote. The answer is very simple. Generally, it's another document. What will happen is HOAs tend to be planned communities. Planned communities actually have community plans, like subdivision plans, that are filed with the recorder of deeds when they're approved, or the county clerk, depending on wherever you are, whoever's doing that. When they're approved, many of those actually contain the HOA rules. And the deed may say, pursuant to the covenants listed in Community Plan 27, recorded in the office of the Fuckwad County Recorder of Deeds, page number such and such. And that's where those rules are found a lot of times. You can't really make somebody beholden to restrictions and covenants, a covenant being a restriction, being a rule that most of these homeowners associations rely on, if they weren't in effect at the time of the deed. So somebody can't retroactively come in and build a bunch of lots around me and then force me as a buyer who owned my property before those covenants came into effect to adhere to those covenants. That ain't got shit to do with me. I bought my property before they existed. I'm not beholden to that shit. Fuck you. Which actually leads me to a funny story. When I was growing up, we had an HOA in my neighborhood. My father, who is also an attorney, had purchased our home before the subdivision plots had been approved in the neighborhood. He bought that land and built the house. And when the HOA came in and tried to assess HOA fees against him, his response was, nope. Nope. Your covenants weren't in effect when I bought my property. Fuck you. So that has happened. That has happened. And with that said, we're in our last 4 minutes of this tonight. So I want to very quickly say a thank you to everybody who has tuned in to the Legal Funhouse. I look forward to coming back next week with another one. I apologize to all the podcast listeners who had to listen to me at the beginning, scurry around to try to figure out if the notification sounds were going through or not. I'm leaving it in because I think it's fucking hilarious. I think it's the most amusing thing that's ever happened. Is I'm sitting here getting these weird-ass notifications in my ears, and not sure if it's bleeding over into the recording software. I think it's great, so fuck you. But now that I know I won't reference it again in the next episode. So until next time, if you want to support us, you can do so over at patreon.com/lawyersandliquor and become one of our monthly supporters. Remember that we do record these every Monday night at 7 p.m. Eastern over at twitch.tv, Boozy Badger, with a live audience. And thank you for listening and tuning in. So until next week, I am Boozy Barrister, Boozy Badger. This is Boozy's Legal Funhouse. Thank you for listening, and you have a wonderful evening. Good night. Okay. Good night, folks.